Good morning. Uh, Recently, multi-number of rape cases are being reported. 5 murder cases, few rape cases, 1 or 2 gang rape cases. It is being reported in all newspapers every day. Unfortunately, though everybody is crying, nothing happened to prevent. However, a case seems to be very pathetic and sensational. Uh, I report this case because if anybody wants to claim for a DNA test or object for DNA test, you can go through this judgment because the judgment contains a multi-number of cases, Supreme Court as well as Bombay, Andhra Pradesh cases, wherein different situations, different views were taken. Here it is AAR 2022, Himachal Pradesh, page 74, Ramlal versus Kumari Priyanka. Evidence Act 45 and 114 about the legitimacy of the child is the subject matter. I have just narrated the incident, what had happened. Plaintiff was the child, not born out of wedlock. She conceived on account of rape committed by the defendant in the month of June 2003, which was disclosed on 15/10/2003 during medical checkup of the mother of plaintiff, who was minor. Therefore, FIR was registered for 376 and he was convicted. Then she filed an application for 125 maintenance. Therein, the defendant wanted to filed an application for DNA test, but the girl objected to it. That objection was upheld. But subsequently, suit was dismissed, filed for the paternity, since there was no evidence for preponderance of probabilities. But pending appeal, she again filed application under Section 45 Evidence Act read with 114 of Evidence Act. This time this girl want to DNA test. That was allowed. Therefore, the defendant, the escaping father, filed 227 CRP. That was decided on various angles. They say though she objected to DNA test when the MC was filed, but she became very same girl filed. But then this High Court, Himachal Pradesh, after deeply discussing with various judgments, held that she is entitled. There is no irregularity, illegality or perversity in the impugned order passed by the additional district judge appellate court for sending her to DNA test. Therefore, that's what I said. If you have to, if you are in the field, or if you are pursuing your postgraduate, it is most important case. Probably this case may be moot case also. Try to understand the judgment. Best wishes.